The Special Tribunal has confirmed a settlement agreement between System Applications Products, which is SAP, and the Department of Water Affairs and Sanitation. It all comes after the court ordered the multinational software company to pay the department 81.5 million rand. Now, before that ruling, the tribunal had declared invalid and set aside 2 software license and support agreement contracts between the department and SAP worth about 1 billion rand. So let's get more clarity. We're joined now by Special Tribunal spokesperson, Adv Selby Makgotho. Very good morning to you. Thank you so much for your time, Advocate. Perhaps before we get into the crux of the matter, let's start right at the beginning. Talk to us about how this came about, because you've now reached a settlement of a whopping 81.5 million rand.
No, thank you very much. Good morning, Sasimpo. Good morning to the viewers, and thanks for having us on your show. What transpired is that sometime in 2020, the Special Tribunal was approached by the applicants in this matter, being the Special Investigating Unit and the Minister of Water Affairs and Sanitation, to the effect that there was a multi-million rand contract that was entered into by the System Application Products, PTY Ltd, and the department. That was in 2015, the first one in December of 2015, and another one in July of 2016. And subsequently, the application was made to the Special Tribunal to the effect that the conclusion of the contract was characterized by irregularities in violation of the Constitution, the Public Finance Management Act, regulations, as well as the department's supply chain management processes. In March 2022, the Special Tribunal granted an order confirming the settlement agreement, because during litigation process, the parties agreed amongst themselves to settle the matter because it was becoming a protracted one, such that it was taking the parties' time. It was confirmed that SAP, being the respondent, would pay in an amount of 413 million rands, but in addition to that, there was 81.5 million that was in dispute. And the dispute primarily resulted from the premise that the SAP had made a point that some of the money was used to service the contract and also involve third parties in as far as the maintenance of the contract is concerned. Yesterday, the dispute in question was resolved and the settlement was confirmed and made an order of the court. And the terms and conditions are that within the next 5 court days, effective from yesterday, this 81.5 million would have been paid into the department.
So, in essence, what more does this agreement seek to do in terms of the 2 parties?
Well, the agreement in effect actually concludes the proceedings between the parties. It seeks to extinguish whatever pending matter has been there. This was a civil recovery process. It would have gone through a protracted process and the parties not agreed to settle the matter. But I must also indicate that the Special Tribunal was very, very much emphatic in relation to the conduct of the parties, because before yesterday's order, during one of the case management meetings preceding yesterday, the parties, we were not happy as the Special Tribunal relating to the draft order that was proposed, because the department was of the view that of the 81.5 million, which was a credit in its favor, as and when they needed services from the SAP, they would just tap into that 81.5 million and then just get whatever services up until the money has been depleted. We rejected that proposal on the premise that it sought to circumvent the procurement processes, and as such, yesterday we were happy that they presented a legally competent order, hence we confirmed it. So the matter is now settled. So now that the matter has been settled, there are 5 court days that the money needs to be paid in, and how will you be monitoring that process in ensuring that the money does indeed reach the relevant account within the 5-day period, and what happens if it doesn't? This is a court order. If it doesn't, they will be in contempt of court, and proper consequences will follow in as far as any other party who does not respect the court order there are consequences. The order actually is legally binding on all the parties, and what we, like with the previous one of 413 million, it's an order that actually it was granted and has been paid, and even the 81.5 million. Should any party, either the applicants or the respondents, have an issue regarding the implementation of the order, they are always at liberty to come back to the Special Tribunal to seek assistance in relation to the interpretation of the order. But from where we stand, we have granted an order, and we expect the parties to implement it without any further delays, because it's clear that within the next 5 court days, so counting from today, then it is 4 court days. So the expectation is that the mid next week by the latest, the department should confirm that it is in receipt of the money.
So how has SAP reacted, perhaps in communicating with both parties, the reaction and what that means for the pair going forward?
Well, most of that because we did not have the privilege to discuss the merits in detail, wherein we were going to be calling the witness, subpoenaing the documents, whatever is required. The parties reached an agreement, but what actually was pleasing to us is that there was settlement, and that was actually adhered to. Had we not put our foot down firmly on the ground regarding the outstanding 81.5 million, one could say there was a little bit of reluctance by the SAP to settle the matter, but through the judicial intervention, the matter has now been settled. So we did not experience any other difficulty in relation to the cooperation of the parties. Hence, the matter has now been settled, and the full recovery has now been made, and the money has been paid in full to the department. Because one of the things is that maybe just to also assist in terms of the background a little bit, is that before this 2015 and 2016 contracts were entered into, there was one of 2012, and the founding affidavit by the applicants alleged that there was a bit of working together by the officials of SAP, by the erstwhile employees of the department, and by some of the service providers. So the evidence actually led to SAP being the one that should be liable for the payment, as the one that has concluded the agreement with the department. Hence, the order directs SAP to be fully liable for the repayment and the recoveries.
Very well. Thank you so much for that, breaking down this matter for us.